Well, good morning, everyone. My name is Chris Bracey. I'm the interim dean of the law school. It's my distinct pleasure to welcome you to the George Washington University. We are honored to host this timely forum. The practice of courts issuing nationwide injunctions has become a very hot topic, fueled by their increasing use in a number of very high-profile cases. We are pleased to join with the Administrative Conference of the United States and the Administrative Law and Regulatory Practice section of the American Bar Association to sponsor today's program, in which experts will be debating the pros and cons of this controversial practice and hopefully add some light to the heat that's already been generated in recent years. We have a stellar lineup today of leading commentators, judges, and public officials eager to get to the heart of this divisive issue. GW Law, I am pleased to say, is contributing two of its finest to today's discussion. Senior Associate Dean for Academic Affairs, Emily Hammond, who will be serving as a panelist, and Associate Dean and ACUS Senior Fellow, Alan Morrison, who will be moderating this forum alongside Matthew Weiner, Vice Chair and Director of ACUS. Now I would like to extend a very special welcome to the Honorable Jeffrey Rosen, Deputy Attorney General of the United States, who will deliver opening remarks today. I also want to welcome our distinguished group of panelists and moderators. But to introduce Jeffrey, we have Ronald Cass. He's a council member of ACUS, the Dean Emeritus of the Boston University School of Law, and President of Cass and Associates. So Ron, please come to the podium.
Thank you very much. Thanks, Chris. Well, I promised to be short, and I think I'm doing as good a job as I can. I have the privilege of introducing Jeff Rosen. Jeff, in addition to being a stellar lawyer and someone who had a long and successful career in private practice, has had a number of very high-profile and distinguished positions in government and in the organizations that recognize the issues dealing with administrative law. He is the former chair of the ABA section on administrative law and regulatory practice. He is a former public member of the Administrative Conference of the United States. He is the former General Counsel of the Department of Transportation. He was also General Counsel of the Office of Management and the Budget. He has been the Deputy Secretary of the Department of Transportation and now is Deputy Attorney General of the United States. Truly, he is a man who has trouble holding a job. But he is also one of the most successful, best known, and most highly regarded practitioners of administrative law. Please welcome Jeff Rosen.
Well, good morning, and thanks everybody for being here. And let me start by thanking Dean Cass for a very kind introduction. I also want to thank ACUS, and I want to thank GW Law, and of course the ABA section of Administrative Law, all of you for thanks for inviting me to speak today. And of course I would be remiss if I didn't thank Matt Weiner, who is ACUS's Vice Chair and Executive Director, and who was also kind enough to recently speak at DOJ's own summit on modernizing the Administrative Procedure Act just a few weeks ago. So Matt, nice to see you again. Today's topic of nationwide injunctions is both important and timely. Many observers have commented on this issue with a focus on legal and policy concerns, and you will hear from a number of them later this morning, including my DOJ colleague, Beth Williams. But what I want to focus on is the practical consequences of these injunctions, inconsistencies and overreaches, both for the government and the courts, that occur when a court goes beyond what is necessary for complete relief to the actual parties who are before it. And to cut to the punchline before I get to the end, it seems to me that the Supreme Court is going to have to address this problem, and I'll explain why. So let me start by explaining what gives this problem its urgency, and that is the exponential increase in the issuance of nationwide injunctions. Though they are coming from a relatively small number of district judges, the volume and frequency of nationwide injunctions has become fairly stunning. It's no longer a once-in-a-decade thorn in the side of the executive branch. While the Attorney General has taken a principled stand against all such injunctions, there is a practical difference between a trickle and a tsunami. And our country has crossed a new threshold where nationwide injunctions have become almost a routine step in a regulation or a policy's life cycle. In the most recent example, just last week, a single district judge in the Middle District of North Carolina enjoined nationwide the U.S. Citizenship and Immigration Service's unlawful presence policy for visa overstays. So, in just a week ago is the latest one. But nationwide injunctions are a relatively recent phenomenon. The first in-depth academic analysis, which was published in the Harvard Law Review, concluded that prior to 1963, there are no examples of nationwide injunctions. Now, even those who dispute that conclusion have pointed only about a dozen potential examples from the first half of the 20th century, which would be in stark contrast to the many, many party-specific injunctions against the federal government during the New Deal era and subsequently. In any event, whether nationwide injunctions date to 1963 or 1939, their frequency today is unprecedented. So according to the Department of Justice's best estimates, we counted 12 nationwide injunctions that were issued against the George W. Bush administration in its 8 years, so 12 in 8 years. We counted 19 nationwide injunctions being issued against the Obama administration, also in 8 years. So that was a 58% increase in the Obama years as the trend picked up steam. During the current administration, federal courts have issued at least 55 nationwide injunctions in just 3 years. That's a rate of nearly 18 nationwide injunctions per year. Or to put it another way, nationwide injunctions are being issued at over 12 times the rate as in the Bush administration. Any assertion that there have been more unlawful practices to challenge is belied by the Justice Department's considerable success in having so many of these nationwide injunctions stayed or reversed on appeal. And that includes the litigation over the so-called travel ban, where the Supreme Court ruled in the government's favor and vacated the nationwide injunctions. Interestingly, in that case, Justice Thomas wrote in a concurrence, the case was Trump versus Hawaii, that nationwide injunctions, quote, are beginning to take a toll on the federal court system, close quote. So what is that toll? I'm going to address 4 real examples that will illustrate some of the practical problems that nationwide injunctions present. So the first example that I'll talk about is the cases of Kerr versus Trump and Barr versus East Bay Sanctuary Covenant. Those cases concerned a DHS rule where DHS had issued an interim final rule denying asylum to aliens who did not first seek protection in a third country through which they traveled and where protection was available. One case was filed in D.C., another in the Northern District of California. Interestingly, the 4 organizations who sued in California were not even subject to the rule. So here's how it played out. On July 24th of 2019, the district court in D.C. denied the plaintiff's motion for a temporary injunction. Later, the same day, the district judge in San Francisco issued a nationwide injunction blocking enforcement of the exact same DHS rule as to anyone, anywhere in the United States. So what did that mean? At that point, DHS was bound in D.C. by a ruling in California, even though the D.C. District Court had sided with the government the very same day. And put another way, litigants who had lost in D.C. were awarded relief anyway by a judge in a different court 3,000 miles away. So the government moved for a stay pending appeal in the Ninth Circuit, and the appellate panel of the Ninth Circuit stayed the injunction outside of the Ninth Circuit, confined it to the Ninth Circuit. The government then sought a Supreme Court stay of the injunction while the case worked its way through those 2 lower courts. But after briefing was complete before the Supreme Court, the California District Court doubled down and entered an order restoring the nationwide scope of the injunction. So a single California district judge, at odds with the prior D.C. District Court ruling, and going beyond what the Ninth Circuit had done, set a nationwide rule contrary to the one the executive branch had set. I think it's fair to say that's peculiar, to say the least. Fortunately, at that point, the Supreme Court intervened to stay the nationwide injunction altogether, pending eventual resolution of the case. So after 2 months of interference with the asylum policy, the preliminary injunction was removed. So that's the first example of the situation with two different district courts and how that played out. Let me turn to another example. Litigation over policies concerning military service by transgender persons and individuals with a history or diagnosis of gender dysphoria. In 2017, 9 individuals and 3 organizations challenged a presidential memorandum on that subject in the Western District of Washington State. Similar challenges were also brought in the Central District of California, in Maryland, and D.C. I'll leave it to you or others to assess why they filed in those particular courts, but before long, all 4 district courts issued nationwide injunctions. After that, in February of 2018, Secretary Mattis announced a new Department of Defense policy, and the government asked that the nationwide injunctions be dissolved. But the district courts in Washington, California, and the District of Columbia refused to dissolve their nationwide injunctions. So the government pursued expedited appeals in the Ninth and D.C. circuits and sought Supreme Court relief as well. What happened then? The D.C. Circuit reversed the denial of the motion to dissolve so that the nationwide injunction out of D.C. dissolved. Then the Supreme Court granted a full stay of the nationwide injunctions from California and Washington that had been entered in the Ninth Circuit. That ended 3 of the 4 nationwide injunctions. For nearly a year, however, the Maryland District Court declined to even rule on the government's motion to dissolve the nationwide injunction. Even after the government had obtained relief from 3 nationwide injunctions, the one from the Maryland court remained in place. So again, a district judge had in effect set a national policy even after the Supreme Court had lifted a similar injunction elsewhere. More than a month after the Supreme Court granted its stay, and only after the government sought mandamus relief from the Fourth Circuit, the Maryland District Court finally stayed its own nationwide injunction. So then, more than a year after Secretary Mattis announced the new policy, was the Defense Department finally able to put its policy in place. Let me talk about a third example, because if those 2 dueling court nationwide injunction issues are not enough, the most recent example of inconsistencies between federal courts in different jurisdictions involves what's called the public charge rule that's at issue in a case called DHS versus New York. So federal law and long-standing federal policies provide that an alien who is likely to become a public charge is not admissible. In August of last year, DHS finalized a rule clarifying the definition of what is a public charge. Soon thereafter, district courts in California and Washington State issued injunctions against DHS's rule, with one of those being a nationwide injunction. The Ninth Circuit stepped in and stayed both of those injunctions. That would seem like a favorable outcome for the government. But the Ninth Circuit's reversal of those injunctions did not allow the DHS rule to take effect, because 2 other district courts had issued nationwide injunctions, one in Maryland and one in New York. Shortly after that, the Fourth Circuit intervened and stayed the Maryland District Court's injunction. So the situation at that point was 2 courts of appeals had lifted the lower court's injunctions, the Fourth Circuit and the Ninth Circuit. But again, DHS could not do anything because there was still an outstanding nationwide injunction previously entered by a district judge in New York, which effectively overrode the contrary orders of not one, but two circuit courts of appeal. District judge in New York, nationwide injunction, even though Fourth Circuit and Ninth Circuit had ruled the other way. At that point, there was a request for the Second Circuit to intercede, but it declined and denied the government's motion to stay that last nationwide injunction. So we had the anomalous situation that the Ninth and Fourth Circuits had said that injunctions were not warranted, but the court in New York directed that injunctive relief nonetheless would be applied in the Fourth and Ninth Circuits and everywhere else. So this situation necessitated that DOJ seek emergency relief in the Supreme Court. And just 2 weeks ago, January 27th, the Supreme Court granted a stay of the New York nationwide injunction. Interestingly, a concurring opinion was issued by Justice Gorsuch, and he aptly described this strange state of affairs. He said, quote, "A single judge in New York enjoined the government from applying the new definition to anyone without regard to geography or participation in this or any other lawsuit," close quote. Letting one lower court direct relief in other jurisdictions that had rejected the very same relief would have been a strange way to run a legal system had the Supreme Court not stepped in to fix that particular case. So let me turn to the fourth and final example for today. I want to turn to the ultimate risk of competing injunctions that direct opposite outcomes which cannot both be met. The well-known DACA and DAPA cases highlight this issue. DACA, which is the acronym for Deferred Action for Childhood Arrivals, was an Obama administration policy to allow certain unlawful aliens who had come to the United States as children to apply for prosecutorial discretion from deportation and for some other collateral benefits. When the Obama administration sought to expand the DACA policy to provide, the acronym became DAPA, Deferred Action for Parents of Americans, Texas and 25 other states brought suit in the Southern District of Texas to block implementation of DAPA. The Texas District Court issued a nationwide preliminary injunction. It was upheld by the Fifth Circuit and then affirmed by an equally divided Supreme Court. So a nationwide injunction against DAPA. Consistent with that ruling, in September 2017, the Trump administration announced that it would end the original DACA policy. But then, more than 10 lawsuits challenged this termination and sought to block the repeal. So there was an injunction against the DAPA being implemented. These were suits to try to block the repeal of a very similar policy. District courts in New York and California granted nationwide preliminary injunctions against the Trump administration's rescission of DACA, and a DC district court vacated the rescission nationwide as well. So 3 nationwide rulings. But that leaves us in the peculiar scenario of both the Obama and Trump administrations each having been blocked by nationwide injunctions, one from implementing and one from repealing what were fundamentally similar programs. In the DACA case, after the Ninth Circuit affirmed the California nationwide injunction, the Supreme Court granted review, and oral argument was heard last November. So we are all waiting to hear from the Supreme Court. But the upshot to date is that a few lower courts have forced the administration to spend more than 2 years implementing nationwide a discretionary enforcement policy that it had repealed after different lower courts and the Supreme Court had barred the Obama administration from implementing a materially indistinguishable discretionary enforcement policy that it had wanted. So whatever you think about the particular policies at issue on either administration, is that how our system's supposed to work? As these examples illustrate, not only do nationwide injunctions allow a single district judge to wield a nationwide veto against federal policies, but they also, and I think this is worrisome as well, create potential discord among the courts themselves. Nearly 1/3 of the nationwide injunctions issued in the last 3 years came from courts in California. Conversely, in 2/3 of all the states, no nationwide injunctions have issued at all. And what these examples that I discussed tell us, especially with the increased frequency of district judge issuing nationwide injunctions, is that the task of ensuring consistency and coordination in the federal court system is a bigger challenge and is becoming a bigger challenge. Why is that? Perhaps a standard concern might be that of litigants forum shopping, at least in part because federal courts are, as I'm sure everyone knows, divided into 94 judicial districts, and responsibility for individual cases falls on approximately 600 or so active district judges and perhaps another 400 or 450 or so senior district judges across the country. Or perhaps this phenomenon is connected with newer or less experienced judges, as more than 2/3 of the nationwide injunctions issued during the current administration came from district judges appointed after January of 2009. At least one Supreme Court justice has focused on the forum shopping concern. Justice Gorsuch wrote in his recent concurrence that I referenced in the DHS versus New York case that, quote, because plaintiffs generally are not bound by adverse decisions in which they were not a party, there is a nearly boundless opportunity to shop for a friendly forum to secure a win nationwide, close quote. If one plaintiff loses, another can try his luck. But if the government loses just once, the enforcement of the law is brought to a screeching halt nationwide, if it's a nationwide injunction. So plaintiffs, therefore, have virtually unlimited bites at the apple, but the government must run the table to prevail, at least until and unless the Supreme Court addresses the case. So in wrapping up, I want to suggest that this practice of judges conferring legal benefits on non-parties to whom other judges had denied relief and enabling transparent forum shopping for nationwide rulings by litigants, these breed cynicism and disrespect for our vital institutions of the law. Now, this is not to say that district courts must all agree with one another all the time. That happens regularly, but with lesser consequences. What I'm saying is that judges should be extremely reticent about, in effect, nullifying one another's decisions in an asymmetric way, as the nationwide injunctions I've discussed are very different from most legal rulings that address only the parties actually before the court. And that takes me back to where I started. It has become increasingly apparent, in the words of Justice Gorsuch, that the Supreme Court, quote, must at some point confront these important objections to this increasingly widespread practice, close quote. Perhaps that will happen soon. In January of this year, the Supreme Court recently granted certiorari in another closely watched case in which a nationwide injunction was issued. The case is Trump versus Pennsylvania out of the Third Circuit. There, the court will review the Third Circuit's affirmance of a nationwide preliminary injunction that blocks exemptions for religious and moral objectors to the contraceptive coverage mandate promulgated under the Affordable Care Act. In addition to addressing the underlying issues, that case provides the Supreme Court with a chance to confront the mushrooming phenomenon of district judges issuing nationwide injunctions with regards to parties who are not before them. So today's conference is indeed timely, and I hope our next speakers and all of you here today will advance constructive solutions to the problems presented by inconsistent and overreaching nationwide injunctions, which would enable our government and the judiciary itself to function better. So thank you, everybody, and good luck with the remainder of the program.
Welcome, everyone. I'm Alan Morrison from George Washington Law School, and Matt Weiner and I are going to be the moderators of the program today. I want to begin by seeing if we can take what Deputy Attorney General Rosen said and try to focus the controversy on the challenges faced. So let me just start with the beginning, that let us all put ourselves in the position of a district judge who has the first one of these cases, either knowing or not knowing that there are other cases around, but suspecting that they're likely to occur, and try to think about what that judge is supposed to do. So for our discussion, we're talking only here today about cases involving the federal government, not the state government. We're not going to focus principally on the law of standing or laws of, relating to equitable injunctive relief, and we promise not to have anybody say, well, it's a uniform policy and a uniform law, and therefore automatically ought to be applied across the United States. We are going to assume, for the purposes of these discussions today, that the plaintiff has standing, and that the plaintiff has prevailed on the merits, and the judge concludes that the plaintiff has prevailed on the merits, because otherwise there's no problem about the scope of the injunction. And we're going to also assume that the district judge has properly balanced the other factors in Winter and the other cases that require before a preliminary injunction can be issued. We're also going to assume that although the cases that Deputy Attorney General Rosen talked about were district court cases, the same kind of issues can arise if rules, for example, have judicial review limited to the Court of Appeals. And in addition, the same principles ought to apply whether it's the beneficiaries of federal programs, as in most of the cases he mentioned, or regulated industries who also seek stays of regulations and may do it in a variety of different contexts, either in the district court or in the Court of Appeals. The same general principles about nationwide or not ought to apply to them as well. So in my view, and we'll test this today with our panelists, the question is should not be always nationwide or never nationwide, but when and under what circumstances. And the public charge case that the Deputy Attorney General referred to is a good example. There were at least 4 separate lawsuits brought by unrelated parties, each of which had a due process right to not be precluded by somebody else's judgment adverse to their views, brought them in places where they plainly had standing, no example of forum shopping. These were all localized plaintiffs seeking nationwide injunctive relief, not seeking class certification for those. This is a situation in which only the United States government was adversely affected by the rulings below. That is, there were no third parties, as there are in other cases, such as the DAPA and DACA examples. They all sought broad nationwide relief in the complaint on behalf of the plaintiffs, claiming in part that without nationwide relief, they would not be effective in gaining the relief for them directly. And so the question presented for each of these district judges was, to what extent can we order relief beyond directly protecting these plaintiffs, and how would that relief be affected? So this program is going to be divided into 2 parts. Let me introduce the panel members. I'm sure everyone in the audience can read their names on the panels there. But in case you can't, let me read them to you in the order which are sitting there, and it's alphabetically, and their bios are in the program. We won't take any time to read them. So we start with Lauren Ali Khan, Solicitor General for the District of Columbia; Ron Cass, the President of Ron Cass Associates, formerly Boston University Law School; my colleague Emily Hammond from George Washington Law School; David Hausman, formerly with the ACLU Immigrant Rights Project, where he litigated many of these cases; Ron Levin from Washington University School of Law; Honorable Beth Williams from the Department of Justice Office of Legal Policy; and the Honorable Stephen Williams from the D.C. Circuit Court of Appeals. So, Matt, you want to take? We're going to divide it into two parts. Matt's going to talk. We're going to try to identify in specific ways the particular kinds of problems that the government sees and the problems that the people who are seeking injunctions see, with limited for them and broad example for the government. And then we'll talk. I will come back up and moderate a discussion on the question of what remedies are possible and appropriate, not simply from the Supreme Court, because the Supreme Court can only issue decisions in cases, by the way, only cases in which it upholds the policy. So, well, I suppose it could, this being the Supreme Court, it could do what it chooses to do, issue advisory opinions. But in theory, it has to uphold the policy and then issue opinion about the extent of the injunction. Matt?
Thank you, Alan. We're going to start by asking each of our panelists to offer brief introductory comments. And then we'll turn to a discussion, which will involve, among other things, my asking questions, but also you asking questions amongst yourselves. It appears as though our lineup here is everybody is arranged alphabetically. So why don't we start, Lauren, with you for your opening comments, and then we'll turn to Ron Cass and so forth.
Thank you for having me. I'm Lauren Ali Khan. I'm a litigator who works frequently with national injunctions. Indeed, I think the district is a plaintiff or an amicus in most of the cases that are in your program. So I'm going to speak to the practical aspects of nationwide injunctions. For impact litigators, nationwide injunctions are a tool to secure meaningful relief for plaintiffs and to respond to fast-moving situations where a large segment of the population is being harmed and it's not feasible to proceed expeditiously on a class-wide basis. I think that there's a basis in history for national injunctions, or for nationwide injunctions. Injunctions sound in equity, and in Missouri versus Jenkins, the Supreme Court talked about how the nature and the scope of the constitutional violation should dictate the nature of the remedy. And so I think that there is a sort of a concrete basis in the law for nationwide injunctions. I think they can be consistent with Article 3. Judicial power is not limited to the district in which a particular judge sits. And frankly, if something is unconstitutional, it seems like it should be unconstitutional everywhere. And so in that way, I think they're also consistent with the rule of law, that similarly situated individuals should be treated alike. I think it's also true that in certain circumstances, harms cannot be contained geographically. I think that applies if you're looking at air or water pollution, endangered species, or even something like the travel ban, where the plaintiff cannot, just by securing relief for themselves in a particular geographical district, resolve the problem because it bleeds across boundaries and borders. I think in that way, it also can be necessary to get complete relief for the plaintiffs. I think the travel ban is a great example of that, where Hawaii was saying, well, if you're not allowing immigrants from these countries or to come into this country, regardless of where they're coming in, it's going to affect our ability for our universities to recruit, for our hospitals to get doctors. And so thereby having any kind of geographically constrained relief is not actually a complete solution to the plaintiffs. And I think they're also really important for judicial economy, and especially as it pertains to institutional litigants in states. States are harmed by federal policies similarly. And so it doesn't make sense to have 50 different lawsuits in 50 different jurisdictions if you can group together and efficiently resolve claims. And so I think for institutional litigants, nationwide injunctions in the right circumstances are a way of advancing and seeking complete relief in order to have an efficient system. And I think this is also something that, as the opening remarks alluded to, perhaps there's this tension between having one district judge saying one thing and another district judge saying another. States face that all of the time. I think about the district's Second Amendment cases, where we have had concealed carry regulations upheld by one district judge in the district, struck down by another. The effect of striking down a district's law is the same as striking down any other state law or federal law. It ceases to apply, and it is to the benefit of anybody who's seeking to strike that law down. And so I think these concerns about having tension among district courts or having conflicting decisions can somewhat be overblown, because that is the normal course of litigation. District court judges are not always going to agree. Courts of appeals are not always going to agree. So unless and until you get to the Supreme Court, you are sometimes going to have the potential for different decisions. And so why not, if there is someone who's decided that a federal policy is contrary to the Constitution, to put the brakes on it until that can be fully vetted up through the Supreme Court. So in that way, I think that also nationwide injunctions can be an important check on executive action, especially at times when Congress, like now, is at a stalemate. And so it allows, I think, the litigants to fully vet issues and to prevent harms from befalling states, other litigants, and the general populace until these issues can be thoroughly vetted.
Ron, you're going to tell us otherwise now.
Well, I always disagree with whoever came before me.
That's
Certainly, injunctions are equitable relief that is traditional and is suitable in some cases. And it's particularly suitable when you have a party before the court who seeks to have something not applied to that person and not applied to people who would be directly having an impact on that person. But when you use a nationwide injunction as a way for one district judge to effectively set nationwide policy, not just in that district and not just with respect to the litigants who are in court in that district, but with respect to everyone nationwide, everywhere, with respect to all sorts of potential applications of policy, you stop the ability of the government to litigate in other settings and other circumstances and other courts, and perhaps get the law developed over time in a way that might not be the same. The simple nostrum that if it's unconstitutional everywhere and ought to be stopped, doesn't make sense if you have different views of what is and isn't constitutional. We have a system that since 1789 has had district courts and circuit courts, although not in the same form they've been in for the last century, and a Supreme Court. And the Supreme Court gets to say what the law is nationwide. District courts, which since the beginning have been narrowly confined to the jurisdiction they represent, the jurisdiction they can reach, the judges are required to be residents in the district. Those courts are not supposed to be setting nationwide policy, and particularly not in issues that are political issues, where you have a political fight going through Congress, going through the executive, you have a resolution of that fight through the political branches, and then you have litigation over it. The litigation is certainly legitimate, it's certainly natural if you have a legal cause of action that is appropriately before the courts, but it is not designed to have one district judge overturn the decisions that are made through the Congress and through the executive branch. There are occasions, and let me go to one of the examples that was discussed by Jeff Rosen, the litigation over DACA and DAPA. If you have a state saying people are being allowed into the country, once in the country, they are allowed to travel if the government decides not to enforce the law against them and send people out of the country who've come in illegally, then I, the state of Texas, will be affected, and giving me relief by allowing people to be removed from Texas alone won't be sufficient, because the right to travel means people can come from anywhere. That is we can talk about, I know it's off the table today, we can talk about whether the standing decision is right. In that case, we can talk about the extent of relief, but certainly there are some cases where relief to the party in the court does require broader injunctive relief. By and large, however, the use of these injunctions incentivizes a search for the court that is most likely to rule in the way the plaintiff wants. And it also is at odds with the decisions of courts in cases like the Mendoza case, where the Supreme Court said that the usual rule of mutual collateral estoppel does not apply to the
Can you explain what that means? What,
Yes, I can. Would you like me to?
please?
The mutual collateral estoppel means that if you and I are litigating that in another forum, I can't assert something different than the result of our litigation, and neither can you. If you go into court suing someone else, you weren't party to the first suit, you're not bound by that decision. But the other person, if I was party to the suit and you're suing me and I'm the government would normally be bound. The other party would normally be bound. That is non-mutual collateral. So it's a controversial concept in many settings. The part that isn't controversial is that it shouldn't apply. Someone shouldn't be stopped from litigating an issue if they were not party to the case that resolved that issue the first time.
Did you have anything more? I interrupted you.
I only have one more.
Please.
And this is a true story, as you will see immediately. There is at the gates to the entry to heaven, the pearly gates, an incredibly long line. It stretches forever. There is a doctor who's been in line for days, and he sees an old fellow in a district judge robe go right up to the pearly gates and go on in. So he gets out of line, he goes up to St. Peter and says, look, I'm a doctor, I've been here for days. That district court judge went right past the entire line. At which point St. Peter said, that was not a federal district judge. That was God. He just thinks he's a federal district judge.
Did you get that from Justice Scalia? Dean Hammond.
All right, thank
Professor
you.
Hammond.
And thanks also for having me. A lot of my remarks and my take on this draws from some work that I did with Alan's and my colleague, Rob Glicksman, where we evaluated what's been happening under the current presidential administration in the courts. We found what we believed to be quite a bit of evidence of what we called regulatory slop, blatant disregard of the rules of administrative law. And within that context, we looked then at what remedies might be available to courts when they encounter this kind of thing. Now, that does not lead me to say that I think nationwide injunctions are always good. My view is that they are an important tool in the judicial toolbox. I don't have quite so cynical a view of how a district court judge might approach the issue. And I do think that this is an issue that would benefit from some guidance from the Supreme Court. But I would hope it would not encounter a ban from the court. Courts, of course, are well equipped to weigh facts and circumstances and reach outcomes in many situations. And so I think that they might consider certain factors in deciding whether to issue a nationwide injunction. Again, granted that we've met all of the parameters that Alan described. First of all, if we're in a court that has exclusive jurisdiction over a matter, I think many of the objections to nationwide injunctions can be taken off the table, at least the ones we're hearing today. So I do want to stake that piece out for a place where a lot of the concerns about conflicting rulings and foreign shopping can be removed. I think that there could be some kind of abstention doctrine type analysis that a court could undertake in view of other proceedings where we are in a situation without exclusive jurisdiction. A court might consider, is this an issue that is very factually bound, something that does benefit from factual development over time, or is this a purely legal question, something that doesn't necessarily need lots of percolating up through the lower courts? Is this a procedural or a substantive error, particularly if we're talking about administrative law? One of the concerns that might be at play is that, let's say, an agency is failing to comply with its procedural obligations in enacting a particular policy point of view or policy dictate. If it fails to do that, it does not have the democratic and the participatory legitimacy that go into justifying that particular regulation or order having the force of law. And in that kind of situation, I think that it's less of a concern to impose an injunction. Where it is a substantive matter and it's a close call, that might be a different issue. And so that might factor against at least many nationwide injunctions. We also might consider how bad is the violation. What is it and how bad is it? So here we would be drawing on the Winters analysis to ask, is this a situation where it is very clear that the government has gone far beyond what the law permits, or is this in fact something that maybe is more open to debate? Again, if it's very clear, I think it's less of a concern to impose a nationwide injunction. And then finally, a court might also, it will certainly have before it any other relief that it's considering. Is this a situation where attorney's fees are justified under the Equal Access to Justice Act, where the government did not take a supportable position in the litigation? Is this a situation where the action of the government is being vacated anyway? Vacation essentially is a nationwide injunction, or at least it has that effect, and so that might also be something that a court can consider. Is this a situation where contempt is at issue? Is a court actually finding that a contempt is justified? Again, these go to sort of how bad the violation it is, but it also has a court looking at all of the facts and circumstances, including the full remedial picture, to determine whether a nationwide injunction might be warranted. So I don't see this as an on-off issue where we should always have them or always not. I do think that there are principles that could be applied to bring some regularity to the discussion, but I do think that courts have more capability than we might give them credit for to consider all of those circumstances.
And we'll turn to some of those approaches when I turn it over to Alan. David, please.
Great, thank you, and thanks for having me on the panel. It's especially nice to be on a panel with Judge Williams, who I clerked for a few years ago. But I want to put me too. I want to put my co-panelists on notice, however. Judge Williams has a kind of sly tendency to ask seemingly gentle questions that are completely devastating. So if I get any questions like that, I'm going to rely on you. So I'm here because I worked at the ACLU Immigrants' Rights Project for a few years and helped litigate a few of the cases that resulted in nationwide injunctions. And you might think that inviting an ACLU lawyer like me to speak at a panel about nationwide injunctions is kind of like inviting your dog to speak at a panel about his favorite bone. But I actually agree with the conveners strongly that the interesting questions here are not about whether nationwide injunctions are never appropriate or always appropriate, but about when and where they are appropriate. And I think it's important to think hard, especially about a couple of things, about when those injunctions are necessary to provide complete relief to plaintiffs, and also about whether there are other doctrines, some of which Dean Hammond just mentioned, that can help address some of the problems that critics of nationwide injunctions have raised. And so to help start that discussion, I wanted to give an example from my own experience. The first case that we at the ACLU brought against President Trump's Muslim ban was a class action, a representative habeas action. As you might recall, when President Trump first signed his ban, there were actually people in planes on the way from the banned countries about to arrive in the United States. And when they arrived, Customs and Border Patrol officers were going to place them back on planes to be deported to their countries of origin, regardless of whether they faced persecution in those countries. So there was extreme urgency in this situation, and as a result, we filed a class action 24 hours after the ban, and we moved to certify a class of everyone who had reached a U.S. port of entry from a banned country and who was likely to be deported. And we moved to certify this nationwide class because of the urgency of the problem. There just wasn't time to address the problem piecemeal. And to illustrate just how urgent this was, we got a hearing at the district court in Brooklyn just a few hours later, and at argument, our co-counsel actually brought a note up to counsel table to let us know that one of our class members was being placed on a plane right at that moment for deportation. And we let the court know, and the court at that moment issued a nationwide injunction to prevent that deportation and the others from taking place. And I think that really illustrates how nationwide injunctions sometimes are necessary to prevent imminent harm. And also, as the first nationwide injunction against the Trump administration, I think people often think about this context when they're thinking about nationwide injunctions. However, this was a nationwide injunction that resulted from a class action. And critics of nationwide injunctions typically exempt injunctions resulting from class actions from their criticisms. And in fact, they say that the problem with nationwide injunctions is not, in fact, that they're nationwide, it's that they stretch beyond the plaintiffs in a given case. So I think it's useful to think hard about what exactly the relevant differences are between a nationwide injunction that follows the certification of a nationwide class and a nationwide injunction that is issued in a case brought by an individual or an organization or a state. And there are a couple of key differences, I think, we can identify at the outset. So first of all, if you bring a class action and you lose, you don't get another shot. You're precluded in other courts. So there is less ability to forum shop. And then secondly, class actions have some procedures to protect absent plaintiffs. So one of the things I'm hoping we can talk about today is whether courts could consider similar factors in deciding whether to issue nationwide relief in non-class actions.
Thank you very much, David. We have a lot of, I'm just sort of looking around the audience, we have a lot of people who work in the administrative law field, and anybody who works in the administrative law field immediately says to themselves, what about the Administrative Procedure Act? And in particular, its remedial provision in Section 706. And that's one of the reasons we have Ron Levin here. Ron?
Well, if that's what you want, that is what I want.
That's what we want, Ron. Alan may not want it, but I do.
Well, that's because I wrote an essay on that very subject in the regulatory review in 2018. And so I thought I would take my short piece here to expound on what I had to say there. The tension comes because 706 says that the court shall set aside agency action that's unlawful. That at least sounds as though it compels national injunctions, and yet that isn't necessarily true. The conclusion I reached in the essay is that the APA basically does not contain an answer to the questions that we are looking at today. And that is true for, my argument has two parts to it. The first is that the term set aside is broad enough that it can authorize nationwide injunctions in some situations. When the APA was enacted, there were already statutes in place that provided for regulations to be nullified if a person showed they were unlawful. Those statutes were called to Congress's attention, and presumably Congress legislated in a way that would also allow that type of relief to exist. But the second part of my argument was just because the statute uses the word shall doesn't mean that it compels a set-aside relief in every case. That's because the statute is subject to a longstanding canon of interpretation, which in various contexts is used to say that a judicial review statute should not be construed to foreclose the exercise of equitable remedial discretion. And that rationale is used, for example, in cases involving remand without vacatur, which by definition is refusing to set aside an action even though it's been found to be unlawful. The courts generally uphold that. So I think the APA is inconclusive on this point, and the ultimate question is, what do equitable principles dictate in situations of this kind? And I won't try to offer a global answer in the 1 minute remaining to me, but I do want to make the point that whatever conclusion we reach should be cognizant that setting regulations aside is a very basic part of modern regulatory practice. Across-the-board relief is inherent in the process of remanding a rule for better analysis, further factual development, for better notice and comment proceedings. You really don't want a situation in which 4 or 5 courts have remanded the case with different instructions to the same agency to look at it in a remand proceeding. And also, as-applied relief is just not a practice in this type of case. You want a pollution regulation to either apply or not apply to the industry in question. You don't want it to apply to everybody except the one company that won a judicial review challenge. I share some of the concerns that have been expressed about encouraging percolation and discouraging forum shopping and the like, but I think we should be wary of embracing broad generalizations about nationwide injunctions that would get in the way of standard judicial review practices that are, I think, working pretty well right now.
Thank you, Ron. Assistant Attorney General Williams.
Well, thanks very much, Matt. I'd also like to thank ACUS for inviting me and to Deputy Attorney General Rosen for his important remarks and for his leadership on this issue.
And you are an ACUS member, I should add.
I am also an ACUS member, that's right. As Matt mentioned, I'm the Assistant Attorney General of the Office of Legal Policy at the Department of Justice, and I'm very grateful to be here to discuss the Department of Justice's position on nationwide injunctions. It's important, I think, to first be clear that across administrations of both parties, the Department of Justice has been has taken the same position, and that's that nationwide injunctions are improper. The Obama administration argued forcefully against them, just as the Trump administration does now. Nationwide injunctions are problematic because they reach beyond the case or controversy that is actually before the court. The department has argued that nationwide injunctions, which go beyond what is necessary to provide complete relief to the parties in the case, violate Article 3 of the Constitution and exceed time-honored limitations on equitable remedies. But I'd like to set those principled and legal arguments aside for a minute and talk about the practical implications of nationwide injunctions. Because many proponents of nationwide injunctions make a fairly utilitarian argument. They say that they are justified because they provide a necessary check on the executive and legislative branches. And my point today is that if you care about balanced checks on the elected branches, you should oppose unlawful nationwide injunctions. And there are a few reasons for this. First, nationwide injunctions threaten to undermine the judiciary's role in our constitutional system by depriving its decisions of their public legitimacy. The Judicial Conference has noted that deference to the judgments and rulings of courts depends on public confidence in the integrity and independence of judges. But nationwide injunctions threaten this public confidence. As we heard from the Deputy Attorney General, nearly 1/3 of the nationwide injunctions issued against this administration have come from district courts in California. This forum shopping could lead the public to conclude that these decisions are more political than legal, and that should not be the case. As Alexander Hamilton wrote in Federalist No. 78, the complete independence of the courts of justice is particularly essential in a limited constitution. Put another way, judges must be independent arbiters of the law and not political actors. But the prevalence of such extraordinary remedies issued after flagrant forum shopping makes it difficult to sustain the public confidence on which the judicial power depends. Second, nationwide injunctions are a check with little balance. Consider that the Constitution established only one court, the Supreme Court, and it does not require that we have lower federal courts at all. It took legislation to establish them. To quote Hamilton again, he asserted that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two branches. Certainly the framers of the Constitution, the 1789 Judiciary Act, and other court structuring legislation never envisioned a system of over 1,000 district judges, each wielding a Supreme Court-like nationwide unilateral power to displace their colleagues and cancel federal law and policy. And I put the question to you, is it an appropriate or constitutional balance of the branches to have each of over 1,000 district judges be a complete check on the President of the United States and U.S. Congress, or is that instead the proper constitutional role of the Supreme Court? Third, nationwide injunctions spark a frenzied litigation process that deprives courts of the full opportunity to explain their rulings. In our tradition, judicial orders are generally written so they may persuasively articulate the court's reasons for its ruling. This statement of reasons engenders respect for the courts and their decisions, and it is part of what makes them such an effective check on the elected branches. But nationwide injunctions spark a rush to and through the courthouse and to and through the appellate process. Often this occurs on a deficient or non-existent record with expedited briefing and expedited decision-making. If the nation's most pressing legal problems are now to be decided on a rushed or emergency basis, a predictable consequence will be a watering down of the court's ability to carefully deliberate and to persuasively articulate the reasons for their decisions. This threatens one of the core reasons that courts are an effective check in the first place. Finally, appropriately tailored injunctions can already be an effective check on the elected branches. For one thing, targeted injunctions often adequately redress the plaintiff's alleged injury. That's all that's needed to resolve the case or controversy before the court. For another, they do not preclude uniformity of federal law. Nationwide or class-wide answers can arise through many different means: the Supreme Court review, agreement among the lower courts, class certification, or even the government's voluntary cessation, where it considers uniform enforcement important or piecemeal enforcement impracticable. Proponents of nationwide injunctions have been too concerned about the immediacy and too quick to dismiss the effective, lawful remedies that are already available. In sum, I hope that our discussion today can wrestle with those fundamental issues. Thank you again for having me.
Thank you. We'll now turn to Judge Williams, who is also an affiliate of the Administrative Conference as a senior fellow, and he contributes much more to the conference perhaps than that title would suggest.
Thank you. And
Thank you, Judge Williams.
thank you for having me. But I want to start actually by saying that it's perhaps rather hypocritical of me to say anything on the subject, because the D.C. Circuit occupies an unusual position, most specifically with respect to regulations where Congress gives us the exclusive jurisdiction to review. So for those, by law, what a panel of the circuit says is nationwide law automatically. That can be one judge, because the panel might split 2 to 1. So it's one judge creating law for the whole country. I would say, by way of qualified justification for that Congress has so decreed, so that makes it different. Even where Congress hasn't given us exclusive jurisdiction, something very similar can happen, in that if the statute authorizing review allows someone who's aggrieved by a ruling to pick a circuit, as it usually does, and it's often circuit in the party's home or the D.C. Circuit, well, once we've held the rule unlawful, obviously they're going to come here. Nonetheless, what I want to do is not actually try to weigh in on the details. It's obviously a complex issue, and I hope that, notwithstanding Alan's warning, it will get resolved by the Supreme Court, or at least the Supreme Court will offer some illumination on it. I want to put the issue into broader perspective, and that is to link it to what I have to say is my personal deepest concern at this point, our current unhealthy political condition. And in talking about this, I want to use the work of Yuval Levin, particularly his book, A Time to Build, but he's voiced the same themes elsewhere, who strikes me as having supplied really the most astute and productive analyses of our condition. Put most simply, his argument is that we've allowed institutions to gradually lose their function as bodies that form those who make their career in them, their character, their sense of duty, their craftsmanship, and increase the chances, and thereby increase the chances that the institutions will function for the benefit of the whole society. Instead of molding participants to operate within a set of principled obligations, he argues, institutions now serve as a platform on which a member of the institution can at best advocate some position, and at worst indulge in pure self-aggrandizement. Election to Congress, he focuses quite heavily on Congress, no longer means learning by practice and example how to develop and mold legislation, how to get it enacted. Instead, it means a platform that might lead to higher office, or at least a role as a frequent performer on nightly news broadcasts. I don't, and he doesn't see this as the fault of representatives or senators. Polarization and other problems have essentially made Congress almost non-existent as a legislative body. So it's natural that the members would be drawn to other activities, which at least have the appearance of giving some result. So where did nationwide injunctions fit in? They offer an opportunity for a district judge to stake out a claim to admiration as a stalwart protector of the rule of law and the Constitution itself. I hasten to add, before proceeding, that I have no reason to think that any particular nationwide injunction has been driven by this problem, but I think it's still a problem that people thinking about the issue should bear in mind. So, on the one side, the judge can stake out a claim as an advocate of the rule of law, a champion of the rule of law and the Constitution. What's the downside? Well, the district court could be overturned by a circuit court of the Supreme Court. Is that a big deal? With the increasing assumption that the law is just politics, observers in many circles will just think that the reversing court was driven by politics. Politics that led it to disregard the vital principles that moved the district court. Let's take the Supreme Court itself. Does a smackdown from it injure the district court's reputation or punish the court for use of his position as a platform? Well, in current times, where the judge enjoining the national government probably identifies with a demographic in which the administration is held in contempt, probably not. The smackdown may be seen not as a blot on the judge's escutcheon, but a feather in his cap. I want to close by addressing the question of how the development of the nationwide injunction might change from administration to administration. As a general matter, it's surely pro-plaintiff, and thus, so far as administrative law is concerned, anti-administration. How completely that is so might turn, at least in part, on how judges view the potential audiences they have. As judges, we obviously write with a view to the parties, with a view to other judges, and conceivably, occasionally, in a rare case, broader audiences. But at any rate, the potential audience can include not only the obvious ones, but the media, the universities, the law schools, educated people generally, the whole population. And all this is magnified by the social media. So the question in terms of the appearance of this phenomenon in future administrations, I think, turns on how you expect judges to think of all these potential audiences and how they might be seen by those audiences. Thank you.
Thank you, Judge Williams. I'm going to turn this over to Alan in about 5 minutes to see if he can bring everybody to consensus on what he calls the solution to the national injunction problem. I'd like to put just a few related questions on the table, which in part go to the question, is there a problem here to be addressed? One of the things that struck me in reading the materials that we've put out for this is that, and as was true also, I think, in the Deputy Attorney General's remarks and in most debates about this subject, is that most of the cases involve immigration. We now have one about contraceptives. We have, I think there's a case in our material about cigarettes. These are obviously visible, divisive, contested political issues. Do we have a national injunctions problem in the run of cases that the courts regularly hear, often out of any outside of any kind of serious public scrutiny? The second question I have is this largely, insofar as it's a problem, is it a district court problem? Is the problem as acute at the Court of Appeals level? Now, of course, there, and perhaps someone wants to talk about it, we do have a federal statute that provides for consolidation of appeals when we have multiple petitions for review, challenging the same order, or more importantly, the same rule. And the third question is does, as perhaps Ron Levin suggested, but I don't want to put words in his mouth, does the APA in the run of cases, does 706 of the APA, the set-aside provision, in effect provide for a de facto national injunction, in particular in cases where a district court judge or a court of appeals remands a case to an agency to revisit a rule, say, because it's arbitrary and capricious? Does anybody want to take any of those questions, perhaps starting with the first? Ron?
Well, let me actually start with the third, because I tend to do things backwards. I generally agree with Ron Levin. I could stop there. I generally agree with Ron Levin on the operation of the APA in the sense that the set-aside language in the APA is ambiguous. It was not thought at the time it was enacted to mean that any time any court found anything wrong with an agency action, that action would be held invalid with respect to all applications everywhere. In fact, set-aside means, in a lot of contexts, simply you set that aside as governing law and don't apply it in the instant case. The laws that were on the table using language like that at the time prior to the APA's enactment largely dealt with common carrier regulation, where if you set aside one of the provisions in a rate schedule, you set it aside for everyone because there was a non-discrimination requirement with respect to common carriage. So you couldn't set it aside just for one. It would be for all. They couldn't charge different people different rates. And laws dealing with restraint of trade, which had a long common law heritage in terms of what was at issue there. But by and large, it was not thought to mean everything was off the table all the time. The other thing that Ron was addressing was the question of whether you have something akin to a nationwide injunction when you hold a rulemaking or some other action invalid and send it back to the agency. And there, a lot of the time, I should say Judge Williams referred to the fact that you have exclusive jurisdiction in a large array of those cases. There are about 130 statutes that give exclusive jurisdiction to the D.C. Circuit or to the courts in the District of Columbia over certain things. So a lot of that washes out from the standpoint of what is already assigned to one court or one set of courts.
Ron?
I think that, as I say, the APA itself doesn't dictate the relief, but we associate the APA with a certain type of case in which very frequently you want a national solution in the manner that I described because a rule itself is being implemented. And I do find that there's a lot of force to the arguments about percolation and geographical conflict among courts that Jeff Rosen was talking about. And so I think you might want to look at measures that would limit the ability of one court geographically located to dictate policy to other ones, which would perhaps mean that some injunctions should be more narrowly tailored geographically than they sometimes are now. But I think that much of this debate has been framed mistakenly by jurisprudential arguments that say that that an injunction should be limited to the parties to the case. And I think the reason that is not helpful in my mind is that it is built upon theories that developed at a time when most policy was made through adjudication. And in that context, it would be perfectly possible to say, well, in the adjudicative case, you can simply give the adjudicative appellant the the enforcement target relief in his or her one case. You don't need to set the whole rule aside so you can allow development of the law over time. And I think that's still true in areas where that is the vehicle. But today, so much of the work of government is done through rulemaking, and so the typical challenge, a frequent challenge, is challenging the rule itself, not the way it's been applied. If you're challenging the rule itself
At a pre-enforcement level.
in a pre-enforcement level, exactly. And when it's that type of case, then it's very difficult to say that the relief should be limited to the individual parties, because so many people who are also affected by the rule should fall within the scope of whatever relief the court grants. And so I see a disconnect between the practical arguments that Jeff was making that relate to whether one circuit should defer to another, and the more theoretical arguments, like the ones Beth was making, that sound more in limiting things to parties, where I think that's less practical.
Do you see instances, are you aware of instances, or how common are instances in which multiple district courts are considering the propriety of a federal rule under, say, an arbitrary and capricious standard, with the risk or the result of inconsistent conclusions as to whether the rule is lawful?
You're asking me?
Yeah, yeah, please, yes. If you know.
No, but I think that typically these cases come up in constitutional context, where you aren't really concerned about administrative discretion in the reasoned decision-making sense. You're talking more about whether it is either constitutional or it's legal in some pure legal sense. And in that context, it's entirely possible that you could have different decisions made in different circuits. My point is it's just less feasible in situations where the agency's reasoning process is going to be implicated, or its procedures. There it's much more likely you're going to want one disposition. And so the theories we come up with should broadly distinguish between those types of situations.
Professor Hammond.
I wanted to maybe pick up on your comment about the standard review that applies, and also your question about is this a concern beyond these very hot policy or political kinds of issues?
And I'm not attempting to diminish the importance of the case, to the contrary.
Certainly, and the point that I wanted to make with respect to these concepts is when we're talking about getting to the point of deciding a remedy, I think it's important to keep in mind that deference doctrines are in operation for the substantive review that the court is undertaking. So courts here are reinforcing those soft Article III norms to the extent that they're not, they're trying to keep themselves from substituting their own policy preferences from those of the government. And it's very hard to win against an agency when those deference doctrines are in operation. And so I do think that to the extent you're talking about run-of-the-mill administrative law cases where these deference doctrines apply, certainly there, again, that's another situation where we already have built-in checks against this concern of courts issuing policy, and looking at the whole case, again, I think becomes more important.
That's an excellent insight. Judge Williams wanted to be heard.
I just wanted to add something on the issue raised about a nationwide regulation which is held invalid in Circuit X. There is a solution which agencies follow with regard to that, non-acquiescence, and in deciding on that, they presumably make a trade-off between the benefits of their choices at that point are giving up nationwide or having a split regulatory system, and they seem to be in a good position to make that choice. So I don't think it's as inherently severe as it may seem. As I say, where the D.C. Circuit is given jurisdiction, that sort of ruins the choice of the agency.
Other panelists? Ron, did you want to be heard?
Oh, I was just going to say,
The problem is here is we have two Rons. So let's turn to Ron Cass
that is a problem, let's face it.
and then Ron Levin,
But two Rons do make a right.
who will make a right. That's right, and often agree.
I just wanted to say, with respect to Judge Williams' point, that normally the ability of the government to have non-acquiescence, which goes along with the limitation on one circuit decision as precedent for another circuit, is affected by the nationwide injunction, because once you have an injunction, then you are obligated to obey the injunction, and there are penalties for not obeying it. It may be what seems like a slight difference, but if you were facing down the barrel of that particular gun with penalties imposed on you as an official, it makes, I would think, a real difference to the people who are charged with enforcement.
Ron Levin.
Well, I was just going to note that the point about non-acquiescence really points up the question of whether a rule is going to be enjoined at all, as opposed to simply declared not to be correct in an individual case in which the government can non-acquiesce to that case, and it is perfectly feasible for matters to play out as a matter of precedent rather than as a matter of wiring injunctions. And that works in the context of applying rules to particular cases. It doesn't work nearly as well in the context of pre-enforcement review, where the actual action being challenged is the rule. So if you win against the rule.
Thank you, Ron. Thank you, everyone. And I'm going to turn it over to Alan now.
Well, I was just going to ask a question about non-acquiescence, but you may want your stamp on it. And that is, my understanding of non-acquiescence is it principally applies in cases of adjudication. That is, the tax agency, IRS, NLRB, and Social Security Administration, and that non-acquiescence is not a doctrine that works if you're trying to enjoin an agency rule, regardless whether it's for the beneficiaries or for the regulated parties. Am I misunderstanding that, or is it, Ron Levin?
I thought that was what I said.
Well, okay, but it wasn't clear that it was adjudications as opposed, it could be a rule or it could be just an interpretation of the statute that was the non-acquiescence is.
Yeah, I can't, to be honest, recall non-acquiescence with respect to the invalidation of a rule. On the other hand, I'm not sure that it makes that much difference, because if you have an adjudication resting on a principle, which one might hope it would, and there's non-acquiescence in that decision, or let's say if there's acquiescence in that decision, then this interpretation, this principle that was followed by the agency, becomes nationwide. If there's non-acquiescence, it doesn't. I'm not sure there's that much difference between adjudication and rulemaking in this context.
Ron, did you have?
Well, I was thinking that it can be a situation where a rule was adopted, it wasn't challenged at the pre-enforcement level, it was only argued in an individual case that the enforcement action should not be upheld because the rule under which it rests was an unlawful rule. But the relief in that situation is directed for the individual. That basically was the standard operating procedure prior to Abbott Labs. That was the tradition. It's only since 1967 in Abbott Labs that we think more of pre-enforcement review, where, as I said, you're talking about the rule itself.
Thank you, Ron.
So let me say a couple of words in introduction to try to get us into the solutions part of this discussion. First, I did agree with Jeff Rosen when he talked about worrying about the practical consequences of this, both from the perspective of over-deterrence and over-regulating and under-deterrence. Second, I think that one of the important questions Ron Levin said, this will work out over time. The question is, over what period of time are we talking about, and what do we do in the interim? David Lansman said before, well, what are we going to do about the people who are about to ship back on airplanes, or people who are being denied immediate benefits of some kind or other? What do we do in the interim till we have all the percolation? And that seems to me to be a problem that we all have to face. Everybody's in favor of percolation, getting a complete record. On the other hand, when people's lives or other important interests are at stake, or the government has important interests at stake, what do we do about that particular problem? One of the points that hasn't been made, but I want to make it now, is that many of the actions of the Obama administration on DAPA and the Trump administration were not formally rules, because there were exceptions to the APA 553 that were considered or argued to be non-rules, and so they didn't come up in the rulemaking context. But what we're looking at is any decision of an administrative agency or the president that has the effect of applying across the board to a wide range of people. And in those situations, we are going to have, inevitably, various people affected in different parts of the country in similar ways, but not identical. And the question I want to try to deal with here is, what do we do about this? So in the Justice Department's submission to the Supreme Court in the public charge case, the government suggests at the end of its brief that what we need in these kind of cases wouldn't be a problem under Article 3 or under equitable principles if we had class actions. So I want to ask Beth Williams, tell me about does the government really want to have class actions in all these cases?
Well,
I warned her that I was going to ask her.
class actions are a structure that exists under the Federal Rules of Civil Procedure, and I think legally they solve a lot of the issues that we're talking about. I mean, I think it's interesting as a moment in history that a lot more people are now standing athwart history yelling stop, and the district court judge in Maryland says I'm the only person who can stop it, and so therefore it has to be done immediately. And it's been suggested that if it's really bad, then therefore it has to be really immediate relief. But I mean, imagine this in a different context. Imagine if there were a company that was making, faulty microwaves, and the microwaves were exploding in people's homes, and a plaintiff went in and said, "This is terrible, and people, are in danger." Would we ever say, well, even though you haven't certified a class, we're going to stop the company nationwide, or would the court give relief to the plaintiff in the case? And are you treating the government, substantively differently? And if so, why? I think we've got class actions, and we've got the protections that class actions provide for a reason. You want similarly situated plaintiffs to be treated similarly, and you want a court to think about that, to think about numerosity and typicality and commonality and the actual protections that are in Rule 23. And so if you're throwing that aside, and if you're throwing it aside only as to one party and not to every other party in the country, we should really be giving some thought to whether that's appropriate.
David, you want to comment on the viability of class actions? Did you actually get a class certified before that order was issued?
The judge actually provisionally certified the class, in that moment. So I guess I'd
So
say in
one would
response-
ask whether that ought to, quote, solve the problem.
Right. I think, well, a couple of things on class actions. I think it's worth noticing that class actions do raise some of the policy problems that have been mentioned. So, for example, the problem that each district court can be a separate check on the executive, that problem exists in class actions as well. Similarly, the problem that plaintiffs might rush into court and get a rush judgment, that might happen in nationwide class actions as well. So in response to this sort of hypothetical about a company, I think here actually the existing standard for issuing nationwide relief is actually helpful, which is that it can only be issued to the extent that it's necessary to provide complete relief to the plaintiffs in that case. And there are situations that are really different from the company microwave situation. So, for example, imagine a situation where an individual plaintiff challenges a religious display in a local courthouse. The relief for the challenge to that display is not that that display gets draped every time the plaintiff comes to the courthouse. It's that the display is removed from the courthouse. And that's what's necessary for there to be complete relief in that situation. And I think the situation in the ban case was very similar in that way, and really isn't analogous.
But that's because people could be entering the state of Washington, for example, or Hawaii, from any place in the world, or outside even the Ninth Circuit.
Correct, and some of the organizations could get clients from anywhere as well, and it would have been unworkable for one organization to be able to get visas for its clients and another.
But that kind of workability and full relief doesn't necessarily apply to all kinds of nationwide injunctions, do you say, David?
I think it doesn't. I think there are differences among cases, yeah.
And that was, I think, part of the point that Emily was making before. Well, let me turn to another question, and that is, exclusive jurisdiction. Should there be more exclusive jurisdictions in the federal courts, or perhaps exclusive jurisdiction if you seek a nationwide injunction? That is, in the complaint, if you seek a nationwide injunction, you have to go to a particular court, District of Columbia, for example. Otherwise, you can get whatever relief you want on a preliminary basis or otherwise in your district court. Would that solve the problems? Lauren, do you have any thoughts about that? Would you want to go under that kind of system?
I mean, I think that to the extent one thinks the problem is so large that it needs to be congressionally taken care of, that is an option. But it seems to me the problem that would be trying to address is forum shopping. And so instead of saying you get to choose where you have standing and venue, you suddenly are routed directly to one court where you're still getting the luck of whichever district judge or three-panel judge, if that's the route you're going, that you draw on your exclusive jurisdiction. So I don't think that it fixes the problem. It just narrows the problem from being national to being in one particular judicial district.
Well, we wouldn't have competing claims for nationwide injunctions, and plaintiffs could get injunctive relief for their particular class of plaintiffs. The public charge case strikes me as an example in that, where all of the harm was confined to the particular physical jurisdiction. That is, they didn't claim that people were coming in from out of state to do that. Would that be, or would that not be a good idea? I'm trying to find some ideas here.
Right. So I think with the exclusive jurisdiction, it would have to go to the same judge every time, or else you're going to get the possibility of different injunctions from different judges within that jurisdiction.
No, any case that filed against the travel ban, if you want a nationwide injunction, you have to go to the District of Columbia, let's say. Once that case was filed there, all the rest of the travel ban cases seeking national injunctions would go to that same judge, just on a related case without any special rules.
And then I think you run into the problem of a lack of percolation. I mean, I think that the cases that Jeff Rosen was talking about this morning, you know, some of the tensions he was highlighting about different district court judges reaching different results, that's just the way litigation works, right? I mean, the fact that we're having nationwide injunctions isn't stopping litigants from filing in different fora and in having the law develop in different ways. The fact that we have, for example, in the public charge case, 2 circuits going one way and the Second Circuit going the other shows that the law is developing in the way that it normally should. And I think if you put something in the exclusive jurisdiction and then route all
a trade-off.
cases,
That's clearly a trade-off.
you're certainly losing that.
Other thoughts about exclusive jurisdiction? Ron?
Well, I think it makes the most sense where you have some particular reason for preferring that court to other courts. The Federal Circuit, that's relatively uncontroversial that you could have national jurisdiction.
But this is not subject matter reason. This is reasons for trying to confine
right, I was getting
the
to that
problem.
By saying you don't have that rationale here. If your argument is simply that you want only one court and you don't care which, then you'd have to justify picking that particular court, which some litigants may not like very much. And it used to be that the D.C. Circuit had, everybody went to the D.C. Circuit because it was perceived to be extremely liberal, and so there was a lot of complaint from the conservative side, everything's going to D.C. Now, there's a system that Matt mentioned where you can have multiple filings and they're all consolidated in some court, and it's
Circuit courts only, it's 21,
circuit courts.
12, yeah.
Right, and it's chosen randomly, right? And subject to a change of venue.
You could do that too, the exclusive random.
Right. So it would be only one court, but it could be any of those courts.
Right. Ron?
Well, exclusivity certainly does solve some of the problems you have with forum shopping if you have the ability to choose anywhere nationwide, and you will have some groups going one place, some groups going another place. You'll have particular places that are thought to be very friendly to one sort of argument and one to another. But if you have a durable commitment to one particular court or to one set of judges, that avoids that problem. And if you have a way of consolidating everything in one court that can't be chosen by whoever is the first to file, that could be another way of solving the problem. It doesn't eliminate every problem, but it certainly does eliminate one set of problems.
So, do we have a situation in which we really have forum shopping in that a particular plaintiff is going around to lots of different places, or do we have almost what we could call plaintiff shopping, meaning that there are plaintiffs in all 94 districts, and an organization, for example, David, like the ACLU, could have chosen to sue in almost any place because they had plaintiffs? Do you see that as happening, or which kind of forum shopping do you see if you do?
I thought the hard questions were going to come from Judge Williams. But, I think that in general, for example, maybe an example is most useful. In the Ben case, we sued where our plaintiff was located, where the highest was located, the Hebrew International Aid Society.
So, I mean, I think part of the problem, Ron Cass, is that we have plaintiffs all over the place, and they will pick plaintiffs to choose in one particular forum. So next possibility. Oh, yes, Beth.
I'd just like to say on that is that you don't necessarily even need to pick. Like if you're doing, you don't need to pick one forum and one plaintiff, because what you see happening is picking 10 fora or 20 fora, right? And all you have to, if you're the plaintiff seeking to stop the action, all you have to do is win once. The government has to win every single time.
So let me follow up with you on that. Suppose we say no nationwide injunctions. Does the government really want to have, as you just said, 10 or 20 of these cases all around the country? Is that good for the federal judicial system? Or is there some interim position we could think about?
Yeah, I mean, I think that's the way the system works. I think that if you have equitable remedies that are appropriately targeted to the plaintiff in the case, if the government thinks that in that particular situation, uniformity of federal law is so important for practical reasons, the government can always decide, okay, we lost in one district, we're going to make it a uniform rule. That's up to the government's decision. But if the government wants to say, okay, well, in this circuit, we will enforce it this way, and in another circuit, we'll enforce it that way, that's also, a question for the elected branches.
Now, many of these cases have come up on preliminary injunctions. The question would this problem be alleviated, or would it be too much if, as far as nationwide injunctions are concerned, they were precluded absent a permanent injunction, meaning that we would have the complete record, we would have an opportunity for full briefing. Would that solve any of the problems? Lauren,
So, I mean, it certainly doesn't do anything for David's client who's on the plane, right?
Well, he can get a preliminary injunction as to himself. He just can't get it nationwide.
Well, I think the purpose of preliminary injunctions is to maintain the status quo. And if the status quo is to adjudicate a policy and determine whether it's constitutional before it goes into effect, the harm of the government in some slight delay, I think, is considerably less than the harm to the individuals that stand to be deported, lose benefits, whatever the issue is.
Other thoughts about preliminary versus permanent injunctions? Ron?
Well, I mean, certainly what the harm is varies from case to case. If the government is making a claim that there is a threat to national security, whatever the claim is, we have to evaluate that on a case-by-case basis. I do think that the preliminary versus permanent injunction is one line you can draw, but I'm not sure it solves that much, because there are certainly cases where the balance of harms is going to militate in favor of a preliminary injunction. It's not all cases, it's not any case against the government, but certainly there are cases where staying something before it goes into effect has relatively small cost and relatively large benefit. There are other cases where the balance could be the opposite. I'm not sure that's really going to solve that much for us. I do think that when you have something that looks so politically salient, so politically contested, a lot of the problem that we're seeing is the fact that people are reacting not as this is simply ordinary litigation, but it is litigation as a form of politics. You have 20, 30, 40 attorneys general from different states lining up on one side of an issue, and they tend to be always the side that has the same politics opposing.
Are you proposing we give new meaning to the political question doctrine?
I think we need
So
the
the
political
judge
plaintiff
should now
doctrine.
say, that in addition to everything else, is this a tough political question, in which case I should do what? More, less, nothing, stay out?
I think that's exactly
I don't
the answer.
disagree with you that these are political questions in the sense that you're using it. But it's, of course, true in the Obama administration, the Affordable Care Act. I mean, can imagine if somebody enjoined the Affordable Care Act on a nationwide basis. I'm sure Beth would think that that's a bad idea. But we didn't worry about it when those cases were going on, or enjoin the EPA's pollution rules on a stay even. Courts of Appeals grant stays regularly on those kind of questions.
Well, I would say the Justice Department actually asked that the Affordable Care Act not be enjoined in Texas recently.
This time, but before, yes. Well, but that's consistent with the Justice Department's position. I agree with that on that.
Well, so some of these questions, by the nature of the subject matter, are going to be politicized because there'll be heavy political commitments on each side. It'll map onto the polarization of the country and the like. I think if you want to try to maintain the legitimacy of the courts, you want to encourage reasoned elaboration of why the stay is or is not justified. And one of the things that troubles me is that so many of these cases culminate in one paragraph decisions on the stay. And maybe that's understandable because of the emergency and the like, but if you said we're enjoining an opinion to follow, and so the judges or justices are expected to spell out why they reached that position, that would be hopefully contribute to legitimacy if they've got a decent case. It would contribute to understanding. And I recognize that emergencies are emergencies, and Beth makes a good point that in that situation, people are in a rush and the like. But if you had more of a commitment to explaining why those stays were entered, even if it is after a delay, maybe that would damp down the politicization.
Some of us have been around long enough to remember when it used to be that the rule was to get an injunction against a state statute or a federal statute, you had to have a 3-judge district court to do so, or the equivalent in the Court of Appeals. Would that be a solution that if you wanted to have a nationwide injunction or arguably even a circuit-wide injunction, you had to get 3 judges to do it rather than one, other than, temporary restraining orders would be excluded from this as in David's case. Does that idea appeal to anybody? Is that a sensible, workable dividing line? Because the last thing we want to do is to create a rule under which there's litigation over the meaning of the rule to get into the nationwide injunction rather than the merits or the breadth of the injunction. Thoughts? Anybody?
Yeah, maybe.
Maybe.
No, but I mean, I'd be interested in something like that where you would say, emergencies aside, you can't do it on one judge's say-so. It has to be approved either by a convened 3-judge court or by the Court of Appeals.
That is, cases go to the Court of Appeals
Yes.
directly. I would be taken care of that way. But the cases that don't go to the Court of Appeals would have to get a 3-judge court to be convened.
My recollection, which is pretty fuzzy on this, is that there were a lot of pragmatic problems with the 3-judge district court system, which is why it went by the boards eventually. And while I can't recall what they were, I have an instinct that we may have similar problems in this case, that if you were litigating something and then trying to decide on the remedy and you need a 3-judge district court for the remedial part of it, it may introduce another layer of difficulty to the litigation.
One of the problems was that because they, in essence, skipped the Court of Appeals because there was no reason to go to 3 more judges, there was a right of appeal to the U.S. Supreme Court directly, which is why so many state statutes were enjoined in the late 60s and early 70s and went to the Supreme Court when there was no conflict among the circuits. But there are some practical problems. And I think what I'm trying to see here is, are there some suggestions? If this problem is as serious as Jeff Rosen makes it to be, then we ought to be looking for solutions, none of which, if we're talking about here, are the kind of solutions that the Supreme Court could decide on in a case. At least I don't think they could decide on a case. So 3-judge courts, anything else to be said about that? So next question is the state, could we do some of this by imposing a heightened standard for imposing an injunction either beyond the circuit or nationwide? In other words, to set up a system under which there would have to be of different balancing of the equities. And this would also require you to take into account the interests of third parties besides the interest of the government who might be affected. So, for example, in the DAPA case in Texas, there were many individuals in the United States who were seriously affected by it, apart from whether the government is itself running its program was affected, and we're required to take those into account. Or similarly, in the air pollution case, the people who would not get the benefit of clean air sooner are workers in an OSHA context. So would that make any sense or help? Beth, do you have any thoughts about that? recognize that you can't commit the Department of Justice.
Yeah, I mean, look, a lot of the proposed solutions kind of assume that some level of nationwide injunctions are okay, and so they aim to kind of, I think, put a Band-Aid on some of the symptoms of the problem. The Department of Justice's position is that nationwide injunctions are never okay.
Never a proper?
The issue of course, sometimes you have to give relief to the parties outside the case where it's necessary to give complete relief to the plaintiff in the case. So, for example, if you're, desegregating a school system, you can't do it just for one plaintiff. You'd have to do it for the school system. No one disagrees that sometimes relief beyond the specific party of the case is necessary in order to give complete relief to that plaintiff. But I think, a lot of the proposed fixes that are different than the Supreme Court just saying very clearly what the law is and what the limits of Article 3, case and controversy are and what appropriate equitable remedies are, that anything beyond that is a symptom alleviator rather than getting at the actual problem.
So when we had the steel seizure case, to take a wild example, when there were only a couple of steel companies that brought suit, and none of the labor unions were parties to those cases, could they enjoin the continued operation of the steel mills in advance? Or the census case, could we have a census that was conducted one way in one part of the country and another way in another part of the country? Fortunately, the Supreme Court was able to get that case litigated by the time that the forms actually had to be decided. One of the problems is that in some of these cases, the orders are coming down from the government, and this is not this administration only, on the eve of a new policy being put into place, so that the ordinary processes of litigation contemplated by the APA, which you've got to give 30 or 60 days notice, you don't even have that much in advance. So what do we do about, is it clear that no place, aside from class actions, that we have it? Would we think that would be proper to enjoin regulations as to part of an industry, but not as to other parts of an industry?
I think the federal government and litigants alike have some desire for uniformity. So perhaps imposing some kind of APA-like standard, a delay in which a rule can be challenged before it goes into effect, could alleviate that problem. And then you have the ultimate determination. Because I don't think the Justice Department's position is, no national injunctions ever, but that the Supreme Court is the final arbiter and they get to say, whether the law gets to go forward or not. And the effect of that is essentially a national injunction, right? And so if we can have time for a case to get through the system and get to a point where either the government acquiesces or chooses to take it up to the Supreme Court and have a decision, and we allow the status quo to be maintained in that interim, I think that is a way in which kind of all parties could be satisfied with the ultimate result. Obviously, that doesn't deal with the emergency type situations where the government would need to put something into effect for national security reasons. So it's not a complete solution, but in something like public charge or census, or these cases that are, the harms to the government are considerably less than the harms to the litigants, it seems like having some kind of process through which this can be vetted before it goes into effect could be useful.
Do you think we're putting too much pressure on the Supreme Court, given all these cases that are coming up, to decide cases too quickly, taking cases before they've even heard from the views of the courts of appeals? In steel seizure case, for example, that went through District Court, Court of Appeals, all in D.C., and went to the Supreme Court. Same is true with other very many significant cases. The Pentagon Papers case, no percolation there as well. So, are we putting too much pressure on the Supreme Court to take all these cases and the path of least resistance and to put on a stay without really considering the merits of the case on the stay?
Well, certainly there are a lot more cases when you have the sort of trajectory that Jeff was describing in terms of nationwide injunctions. There are a lot more cases coming up a lot more quickly where there's a nationwide injunction being put in place, and there is pressure to have this go up to the court, because otherwise you have one district court barring the implementation of a policy for the entire nation. And since we do have turnover in government, one of the games that is played by both political parties, both sides that are affiliated with political parties, is if you can delay something long enough, you can get another administration in, and then it can repeal whatever was done. So I do think that there is increased pressure on the court. There is increased pressure to take things quickly. There is increased pressure to take them without the development of the sort of record you would like to have. There are some sorts of cases where you want to do that anyway. It's just too important not to. But I think that the number of cases where the court is under pressure to take it quickly has grown very substantially over the last decade.
So would it be ameliorative, if that's the right word, for Congress to pass a statute saying district courts have no authority to issue injunctions beyond the circuit in which they're sitting? All right? Just leaving aside some seepage problems of the kind that David talked about before, assuming that they could do that, would that solve some, a lot, none, most of the problem, or not worth doing? Any thoughts?
It would certainly solve some problems. It would cause other problems, but it would solve some problems.
Well, that's what we're trying to figure out here. Which ones are, is the cure worse than the problem?
I think I agree with Beth. It's just alleviating one symptom. So instead of saying you're saying I trust Court of Appeals judges more than I trust district judges.
Well, there are at
It's
least
just
three
narrowing
of them.
Focus.
At least, no, the district court would be able to issue an injunction, but it could not extend beyond the circuit. That would be the terms of the statute would have to be passed to say that.
We're not just talking about we're not talking principally about geographic limitations here.
That's the court, because in a rulemaking context, obviously that doesn't do much for the rulemaking context if it were interpreted that way.
Also, and I think Ron made this point, you can't discount stare decisis. If a district court makes a decision and with regard to one specific plaintiff, and that goes up to the circuit court, and the circuit court agrees with the district court, that effectively is the law in that circuit. It applies geographically just by virtue of stare decisis. So whether you actually issue injunctive relief is less important because that circuit law is going to control.
I wasn't clear. My point would be that the district court's order itself, the first order, regardless of the merits, could not extend beyond that circuit. That is, the government would not be bound to follow it if it was against the government in another circuit while the case was either litigated or not litigated in another circuit.
If it protects the plaintiff, though, in that particular case, the government is obligated to adhere to the injunction throughout the world, right?
As to the particular plaintiff,
As to
yes.
the particular
But otherwise,
It's not a geographic issue per se.
right.
Right.
So, all right, I've given all of the solutions I've got on my table. Does anybody else have another idea for a solution besides always Judge Williams?
This isn't a solution, but I did want to question your observation at the beginning that the Supreme Court would be able to address the issue only in a case where it upheld the ruling on the merits. I don't think that's true because, you might think that where it invalidated the ruling on the merits, the nationwide character of the injunction issue was moot. But courts don't operate that way.
Well,
if there are two fatal arguments, potentially fatal arguments against an order, each independently completely fatal, courts, rightly or wrongly, but they do historically, feel free to take one, you lose on this ground, two, you lose on that ground. So I don't, it would be a slightly different issue.
maybe the courts of appeals do that because they're expected to defend themselves against higher Supreme Court rulings.
We do have that excuse.
But the second on this one would be part of the rationale. The hard cases on the extent of the injunction are those cases in which the plaintiff is correct on the merits. If the plaintiff is wrong on the merits, it's an easy case to say no nationwide injunction. Ron?
So I had the same reaction with Judge Williams. The case the Supreme Court wants is the one where they say, what would happen below is just outrageous. And moreover, they extended it nationwide, which makes it all the worse. I don't think the court wants to take the case, well, yes, really, this side really deserved to prevail, just not as much. They don't want to do that. They want to make a strong statement and then let the lower courts clean up the mess.
In that kind of a case, it wouldn't answer the harder case where the plaintiff is right on the merits. And then what do you do about the scope of the injunction? And that's what I consider the hard cases. It's easy if the plaintiff is not right on the merits. That's an easy case to say you should obviously not issue any injunction, let alone a nationwide.
But I think that the solutions here may be structural in the way we talked about in the earlier discussion. They may be doctrinal. And with regard to the doctrinal, I would picture the court writing an opinion that probably is easy because then you can get at least 5 to sign, but it has vague dicta, which then gives some guidance to the lower courts where they say, well, this case is, not as bad as that one, so we don't need to follow it, or this case is so much like the other one, we really have to follow it. I think that's exactly how it would work.
Yeah, and I agree with Ron there. I mean, if the plaintiff's right on the merits, the Supreme Court's going to strike down the statute, and it's going to apply not to just that plaintiff, but everybody else. And I think that's just the way the Supreme Court functions as a matter of course. And so I think the situation in which it arises is where the plaintiff is egregiously wrong on the merits, and the court is just, completely floored that this has been a rule extended across the entire country.
So we have generally not been talking about challenges to statutes because they present a somewhat different problem. And some of these cases are strictly, as Emily said, procedural APA case you didn't follow notice and comment. Some are arbitrary and capricious. Some of them you violated the statute. Some of them you violated the statute and you infringed on the First Amendment rights of somebody. So these are all kind of mixed cases, and it's hard to separate them out on subject matter because often, certainly the plaintiff tends to allege as many different violations as possible. Does anybody have anything else they want to say? Because I'd like to throw this open to the audience. Does the audience have any comments, suggestions, questions that they would like to ask? I don't think we have a microphone, but that shouldn't stop anybody in this room from coming forward. Come on up forward to the front here and pose the questions. We have somebody down there? We have a microphone? Oh, great, we have one. Sorry. Just please give us your name and your affiliation of some kind, so we know.
Good morning. I'm Jill Larrabee, and I'm a regulatory attorney in the aviation sphere. I was just curious your thoughts on the use of self-executing language in response to delay under the APA, sometimes taking up to 4 to 5 years. Is that too tough of a question?
Clarify it?
Sure.
The use of self-executing language by Congress. So the Congress has passed a statute. The agency has taken 4 to 5 years to implement that under the APA. Under a rulemaking, in response, Congress enacts a subsequent statute that says, if we weren't clear the first time, we'll be even clearer and say, we're going to completely bypass the APA.
And somebody's bringing an action to require the agency to do something?
Correct. I'm just curious their thought on the use of self-executing language to bypass the entire Administrative Procedures Act.
Anybody? It seems a little off target. Because it's not a nationwide injunction. If any court orders them to do it, they'll have to do it for everybody. Beth?
Yeah, I mean, look, if it's a statute, you've got far fewer, you wouldn't have any APA challenges, right? There's no plaintiffs challenging all the APA because they're not challenging the regulation, they're only challenging the statute. So I guess, I don't know how it would impact nationwide injunctions, but I think, the same concerns about nationwide injunctions would apply to statutes as apply to regulations.
If the issue is delay, so you might have the agency that is perceived to be dragging its feet, and so people bring suit in a variety of forums to try to get them to hurry up. And there you do potentially have the fact that the most impatient judge will control all the others.
I had a question. If you had a procedure where plaintiffs could litigate in multiple fora, but the decision for preliminary injunctive relief would be assigned through the JPML or through another process to one particular court. Would that allow for percolation, but also sort of address the question of?
So I take it you're thinking about the multi-district litigation panel?
That's right.
Yeah, that typically involves situations in which there are multiple actions filed, not 2 or 3 or 4 as we have here, and the current procedure requires that applications be made to that court, and then they hold a hearing to decide whether they're going to take it or not. Often they don't take it the first time, and then they send it to another court. That's going to be rather difficult to implement on that current basis for dealing with problems that require preliminary injunctions, or at least in the view of the plaintiff.
It also, as I understand it, with the district court, the MDL, it only deals with pre-trial proceedings.
Yes.
Pre-final judgment proceedings.
They could issue a preliminary injunction, but they couldn't issue a final judgment. Can't go to trial on it. So, I mean, in the sense of sending these to a forum that would send it out to one judge to deal with the.
Or it could be a 3-judge panel.
Or 3-judge panel. Yes, yes. That's kind of how we would get to the 3-judge panel thought. Yeah. That's certainly a thought.
So we've touched on some of these issues, but it seems to me that at the core of this is a real constitutional question, and that the judicial branch is being forced into this position, at least in some cases. If you don't believe it's happening now, it could in the future, by congressional inaction and by executive overreach and illegality. So assuming we think that there is a problem, it seems like we here are only discussing potential solutions within the judicial branch. Do the panelists think that it's appropriate to only be discussing judicial solutions, or are there potential executive and legislative branch solutions that we should be looking at?
Well, just to be, thank you for the question. I had hoped I was clearer. Almost everything I've suggested here would require Congress to do something. Maybe the Supreme Court could impose a higher standard for preliminary injunctions for nationwide classes, different balancing of the factors. But otherwise, I think most of the rest of these things could not be. The Supreme Court could simply say no, and we could have class actions. But some of the other solutions that we've talked about here would require Congress and
sure, no,
recognizing.
totally understood. But I guess my question was, should the solutions be oriented towards changes to the executive branch, to the congressional branch, instead of congressional solutions that address the judicial branch?
Congress should resolve more questions, and the executive should not abuse its authority.
Here, here. Right, and so then the judicial branch is now currently.
Yeah, they have less to
forced
do because there are fewer
act.
problems to solve.
Yeah.
Then what happens to lawyers in law schools?
That would be the tragedy.
So did you have any specific things in mind?
Yeah, I mean, I think that there could be some potential creative solutions around whether the executive branch, what powers the executive branch can use, maybe more APA process. You know, I mean, I think we're being forced to look at new ways that the balance of powers is potentially being abused, and or there's a lot of tension there. So I think, you know, we're trying to look for this judicial solution, but it seems to be far too narrow of a solution, I guess is my point.
Well, I think in part we're looking at judicial solutions because we're looking at a judicial problem. The question is the scope of the remedy, what's the appropriate scope? And you know, while it's always connected to other things, I think that's where we've been training our angle today.
Well, surely an administration could take the position that except in absolute emergencies, which of course they would have the ability to define, we will not have a rule anything go into effect for 90 days or 180 days. That would alleviate some of these problems. Most administrations would not want to do that. And so, you know, self-regulation may not be the answer in that particular situation. But the APA now requires 90 days, 30 days. Some agencies have 60-day statutes as well, except, of course, when good cause is shown, in which case they can put it into effect sooner and so forth and so on. So it's very hard to close those loopholes. Yes, next questioner.
Hello, I'm a third-year law student at American University. My name's Thomas Barker. I think I agree with Judge Williams specifically in that the politicization of the courts has been an underlying issue herein. But I guess my question is more towards, if we're talking about not having nationwide injunctions or not limiting the issue to only the parties, what about the government? Should they be able to argue wildly different reasoning for the same regulation in two different courts and try to get a different result? Because I think that's been the case in more than one situation. I'll take my questions.
Well, I'm not aware where the government is arguing different reasoning in different courts. I think you've seen some different results in different courts, but I think the government's positions are generally uniform.
Or if they're not, they're at least arguably uniform.
Yeah.
It changes over time.
Yeah, it changes over time, but I mean, in the same issue, like, you know, in the same time period.
It sometimes gets refined, but
Right.
it's not inconsistent.
Right.
I'm Emily Nessler. I'm from the Center for Reproductive Rights, formerly at DOJ. I am curious if we're using the term nationwide injunctions as shorthand for nationwide relief. People have touched on the issue of vacatur, but to me that's different in kind, if not in effect. And I'm particularly interested in knowing if that is the DOJ's current position, because I didn't understand that to be the position when I was there.
Sure. So DOJ's position has been consistent across the administrations, which is that not all nationwide injunctions are unlawful, but unlawful nationwide injunctions are the ones that give relief beyond the parties to the case, where that relief is not necessary to give complete relief to the actual parties. That's DOJ's position.
So does that mean that, like, that would include vacatur on a final judgment? I mean, that's because, like, that is something a little different, right, as opposed to what we've been talking about today. The cases we've been talking about have basically been preliminary injunctions, whereas if you have a final judgment, you know, is vacating the rule then not the appropriate remedy in that situation?
Yeah, so it depends. I mean, it kind of depends on the case, right? But I think that the position is the same with regard to both preliminary and permanent injunctions. If the relief is broader than necessary to actually give relief, complete relief to that plaintiff, then it's not appropriate, and we argued unlawful.
Could I press you on that a little bit and ask you for an example of relief? That we use the word necessary for the plaintiff. Do you have any injunctions that are broader than appears to this plaintiff that it would be necessary? For example, the initial let's take the initial travel ban and forget about the merits for a second, because there were the decision that was ultimately upheld by the Supreme Court 5-4 was, I believe, the third version of the travel ban. But the first version of the travel ban prevented people from coming into, let's just say, Hawaii or the state of Washington. Am I right, David, on that?
Yeah.
And people could come any place from around the world to get there. Would a nationwide injunction in that situation to protect the plaintiff, assuming the plaintiff is correct on the merits, would that be reasonably necessary in the view of the Department of Justice or not?
Yeah, well, I don't want to get into, you know, specific cases or hypotheticals like that.
I had suspected I was going to get
But I mean, but I think the example I gave before.
I wasn't going to stop me from trying.
Yeah, no, but I think the example I gave before, I mean, is appropriate. You could imagine that if you're desegregating a school, you can't just give relief to that one place.
That's not
right?
But that's Little Rock, Arkansas. It's not the whole United States.
Right, but I mean, it's what's necessary to give relief to that plaintiff, right? That's the question. And when you know, the Supreme Court decided that case, that in effect gives nationwide relief.
Well, it didn't, according to when Cooper versus Aaron came up 2 years later. They took Arkansas took the position they were not bound. The governor of Arkansas took the position he wasn't bound, and there was no injunction against him. The Supreme Court ended up saying, no, you can't do that. But it, you know, it took a while. Ron, did you?
Well, that was stare decisis, a very strong stare decisis.
Yes. So, other solutions, David?
I'm just happy to jump in and say I think in that case, a nationwide injunction was absolutely necessary to provide complete relief. In addition, I think it's worth just noticing that when the second version of the Muslim ban reached the Supreme Court stayed the injunction in part, but did not alter its geographic reach. So in that decision, the Supreme Court effectively approved the nationwide injunction that had been issued below.
Okay, I see we're just about out of time. Any final comments from any of the panel? Should we go down the panel? And Lauren, anything else you want to add that we've cut you off from?
No, I mean, I think this has been a great discussion. I think it shows that we are all eagerly awaiting what the Supreme Court has to say. And depending on that, maybe Congress will have some work to do.
Ron?
And we'll be drafting different versions of that.
Yeah.
I think we've identified the fact that it's a complicated issue to which there's no easy solution, and we should have more panels.
Emily?
I actually want to endorse Ron Levin's point about having thoroughly reasoned judicial opinions that are transparent about the factors considered. I think that alleviates some of the Article 3 concerns and also perhaps develops some precedent so that we do have
Talking about on the motions for stay in particular?
In considering whether to grant a nationwide injunction.
I just wanted to call attention actually to something Dean Hammond said at the beginning, which is that courts could actually consider doctrinally some of the forum shopping issues, in the sense that a court deciding the fourth case against a given rule might weigh that fact in deciding whether to issue the injunction.
It doesn't help the first court.
That's right.
So I was just casually wondering whether there's anything that the Administrative Conference of the United States could do by way of setting forth framework for analyzing this? I think that's a bit of a premature question, but just a thought that might bear some reflection over time.
I'll say a word about that.
Please.
Yeah, I just want to echo the other panelists. I always enjoy these discussions, and I think if everybody can agree on more thorough, well-reasoned, transparent opinions, that's a good thing.
Things that everyone could
Yeah,
agree on,
yeah,
not
we
to
can
get
agree on.
adopted.
That's right.
We agree on procedure, not on substance.
I just, there's been a suggestion at a number of points that the whole situation arises out of an administration acting at the edge of its powers. But of course, that depends on how broadly the powers granted by Congress have been defined by Congress. And so far as I know, only one person in this room is working on doctrinal change to limit that, our chairman, Alan, and it'll be interesting to see if you succeed.
Thank you. Thank you. So let me thank everyone for the participation and turn it back to Matt.
Previously one judge.
Thank you very much. I think we may, one observation I have after listening to this, I think we may need, as other commentators have pointed out, another term for, instead of national injunctions. It conflates a number of different considerations. Secondly, I was, in response to the question I think that you had answered, Beth, in the garden, correct me if I'm wrong, but in the garden variety pre-enforcement challenge on the ground that say a rule is arbitrary and capricious, nobody's seeking a national injunction, and that's not the disposition that's set forth in the case. It's, I think the disposition would be to vacate the rule and to remand to the agency for further proceedings with, consistent with the opinion. Ron, sometimes vacator is not appropriate, as Ron has pointed out, but these cases are not cast in terms of national injunctions. Finally, in response to Ron's comment whether the Administrative Conference of the United States could play a role here, my answer is as follows. I think we can consider. I think we should seriously consider whether the conference might make a statement that identifies some relevant considerations for the courts, though we generally do not make doctrinal recommendations to the federal courts. Most of the recommendations directed to the courts are directed to the Judicial Conference of the United States in its rulemaking capacity. That said, we also have made numerous recommendations in the past to Congress about judicial review, and in fact, some of those recommendations have been implemented. The conference has issued numerous recommendations on the choice between review in district courts versus courts of appeals, and when it's appropriate for rules in particular to be reviewed in the courts of appeals as opposed to the district courts, and then in some cases exclusively before the DC Circuit. And that leads me to my final comment. The Administrative Conference is undertaking a project now in which we are reviewing every judicial review provision governing the review of adjudicative orders and administrative rules in the United States Code. The conference staff spent many months going through the U.S. Code and identifying as best we could all relevant provisions. We've now turned that database of information over to John Siegel of the George Washington Law School, who also happens to be an ACUS member, and John is going to try to synthesize some of that information and put together for us a guide to judicial review, which will be, everybody's welcome to read it, but to a large extent it will be directed to Congress. And it will address such matters as when and under what circumstances Congress might wish to vest the review of agency actions in courts of appeals as opposed to district courts, and among courts of appeals in particular circuits. And the DC Circuit obviously is important in that conversation. So that guide is forthcoming. I think we will certainly see it before year's end. And I hope that it will provide some useful empirical information as we and Congress think about the questions that we've addressed this morning. Lastly, one of our members, Adam White, who directs the Gray Center at George Mason University, literally just posted on the Yale Journal of Regulation website, its blog, the notice and comment, a proposal. I think he put it up last night or first thing this morning, and he's proposing a lottery system by which, if you have multiple cases filed in district courts involving the same subject matter, that the MDL panel would assign it by lottery to a particular district. I don't know that I don't know if that would command any agreement, but it's an interesting piece that I call to your attention. And with that, I'd like to thank all of our panelists for giving their scarce time to us this morning, and especially for everyone in the audience here for giving their time and coming out this morning and listening to this important debate, which will continue in many forums, including at the administrative conference. Thank you.